All right, let's get right into it. If you're co-parenting here in Washington, D.C., you already know that fights can pop up over just about anything. But one of the biggest headaches? It's extracurriculars. So today, we're going to break down your actual legal rights and what you can do when you and your ex just can't see eye to eye on your kids' activities.
So let's kick things off with a scenario that unfortunately plays out all the time in the DC Superior Court Family Division. And for many of you watching, this is going to sound painfully familiar.
Yep, there it is, that text or email that just drops a bomb on your day. Suddenly, your kid is on some pricey travel team or in a new music program, and you had zero say in the matter. The decision was made for you, and you're left to figure out the mess.
And this is the most frustrating part, right? A simple conversation about soccer practice somehow spirals into a huge conflict. Your child is stuck right in the middle, and you're staring down the barrel of a legal fight that is just going to drain your bank account and your sanity. Knowing your rights is how you stop that from happening.
Okay, let's get into the nitty-gritty of the law right here in Washington, D.C., because what you can and can't do isn't just about what feels fair, it's about what the law actually says.
Pay close attention to this one because this is huge. If you have joint legal custody in D.C., and most parents do, that word consult is a legal requirement. This isn't just a nice suggestion or a courtesy. Your ex is legally obligated to discuss major decisions like a new extracurricular activity with you first.
Now this chart shows something absolutely critical under D.C. law. See, child support? That's for the basics, the absolute necessities like food and a roof over their head. But extracurriculars? The law sees those as discretionary. They're optional, which means the rules for who pays and who agrees are completely different.
So here's the bottom line. Your parenting time is protected. If your ex signs your child up for something on your time without your consent, you are not legally obligated to take them. A last-minute baseball practice is not the same as a required doctor's visit. They cannot force you or your schedule to bend to a decision you never agreed to.
So what happens when you've tried talking and you're just at a total standstill? What are the actual practical things you should be doing when you really don't think an activity is a good idea?
Listen, DC judges want to see that you've made a real effort to work together. So before you just shut it down, follow these steps. Get all the details in writing, clearly explain your concerns, maybe even suggest another option. And, this is so important, document everything. It shows you're trying to be reasonable, not just difficult.
You got to remember this phrase, because it perfectly sums up how DC courts look at this. If one parent goes rogue and enrolls the child without the other's agreement, then they are almost always on the hook for 100% of the cost and all the transportation on their own parenting time. Your time, your dime.
Okay, so what if you've done all that? You've documented everything, and there's still no agreement. Do you just run to the courthouse and file a motion? Well, not so fast. The DC court system has a very specific process for this.
In fact, the D.C. Superior Court has a very strong opinion on how these disagreements should be handled. Before a judge even wants to see you, they're going to expect you to try something else first.
And there it is, mediation before litigation. The courts in D.C. don't just encourage this. For these kinds of disputes, they often require you to try mediation first. They want you to try and find a solution together before you declare war in a courtroom.
And there's a good reason why. I mean, think about it. Mediation is way cheaper and faster than court. It's designed to be less of a battle, which helps preserve whatever co-parenting relationship you have left. And, maybe most importantly, you and your ex get to control the final decision, not a judge who doesn't know your family.
But look, sometimes even mediation isn't enough. There are times when you absolutely need to bring in a professional. So let's talk about when it's time to get legal help from someone who really knows the DC court system. If you're seeing a pattern, if your ex constantly ignores your custody agreement, makes big decisions on their own, or if you two have just stopped communicating entirely, that's the red flag. At that point, getting a lawyer isn't about starting a war. It's about enforcing the rules that are already in place. And when you reach that point, you need someone who knows the DC courts inside and out. The expert behind this explainer, attorney Carlos López, has spent over 2 decades in DC Superior Court. That's the kind of hyper-local experience you need to craft an agreement that can prevent these problems before they even start.
You know, at the end of the day, this is what it's all about. This isn't really about winning an argument with your ex. The real goal is to create a world for your child where they feel stable and supported by both of you, even if you're not together anymore.
So, we want to leave you with this one question to think about. A weak, vague custody agreement is just a recipe for years of fighting. A strong, clear one is a roadmap for peace. So take a serious look at yours and ask, is it really ready for the real-life challenges of co-parenting in DC?